Hi, my name is attorney Walter Rudolph Hnot III. I'm with Disability Resolution PA, and the tutorial video that I'm going to be creating today is talking about how the administrative law judges are changing the way that they adjudicate claims in 2019. Okay, so let's talk about who these people are. First, ALJ, that's the person, administrative law judge, who's going to adjudicate your claim at the hearing. That's where you're actually in a hearing in front of a judge. How are these people changing? Well, their bosses have handed down a lot of new orders, specific questions relevant to things that they need to address. What's changing is how they question the vocational experts. When the vocational expert gives something that's not already in the DOT and it's just in relevance to, their knowledge, experience, their background, yada yada, they have to go into detail as to how they concluded that information. And one of the things that vocational experts don't like is to have to give statistical information that's not already provided in SkillTran or the DOT. And if they do that, you've usually got to look into it because they might just be pulling it out of their hat to give some sort of relevant information for the judge that might not actually be accurate. The big thing that we're all focusing on in 2019 is where they come up with these numbers for how many jobs are available in the national economy. A lot of them just hire a company to give that statistic. It's still good to ask. It's still very good to check in as to why is that so. Another thing is that the judges will basically ask a whole lot more about your work history. The work history evidence that you provide throughout the initial filing and reconsideration levels are basically, it's all on one form. It's a 3369 for the most part. It might be an 820 or 821. It might be one of those, but for the most part, it's a 3369. And a 3369 is just about your work history. Where'd you work? What'd you earn? What'd you lift? Did you hire or fire people, etc.? So the judges are being pushed very heavily to ask more information about each job that you worked. And there's two reasons. Reason A is they're looking to see if element 4, you can, the 5-step sequential process, whether or not you can do the jobs that you did within the past 15 years, because they need to classify them for the vocational expert. That's not the important one. I mean, it is, but it's not the really important one. The thing that they're doing a lot of in 2019, the really important one, is that they're basically looking to see whether or not you were working in, the latter years near when you were found disabled, if you're going to be found disabled, so like 2018, 2017. And usually your alleged onset date will be, a couple of years back from when you're actually at that hearing. And upon that occurring, they'll look to see if you have any months that can be used to claim that you shouldn't receive those months in disability benefits. So let's say you had a failed work attempt where you worked for 3 months. If you had a failed work attempt where you worked for 3 months, then in that particular case, they can use those 3 months so long as you earned over SGA amounts to go ahead and deny you payments for those months because you were working and earning. Now, I know what you're thinking. I waited all this time. I should be able to get all the funds that are available month by month due, month by month to me, and so on and so forth. And I'm clicking around the computer to get some things up. But the bottom line is that you are not really due or eligible for those months that you were working and earning, because the whole point of this program is that you can't work and earn in the national economy, ergo you are disabled because your severe disabilities caused your inability to work. So they're looking to see if they can get some months out of the back pay or potential retroactive benefits that you would get. That's what they're looking for. That's what they're trying to achieve here. They're trying to save the SSA some money by removing those months. Now let's talk about it a little bit here. We talked about how the judges are looking at what jobs you did a little bit more seriously, specifically with reference to those you recently did. The judges are also looking for illegal activity that causes a potential for abuse of funds. All right, so what do I mean by that? What's illegal activity? Let's start with one that's really easy, then we'll go to one that all of you, that a lot of you do that is wrong and you don't realize it's wrong. All right, so the thing you need to remember is like, okay, so let's say that you are out there buying cocaine with your disability funds, right? That is super illegal for a lot of reasons. You know why. Another one that is incorrect and for the most part now being adjudicated as illegal or capable of removing the funds from you for purposes not for the support of your disabling conditions. You should not and do not have the right to buy cigarettes with your Social Security disability funds. You know, when it's pertaining to disability benefits. Those funds are for your general upkeep. Smoking cigarettes is not considered part of general upkeep. And here's how they do it. You give testimony that you are, so let's say that you're found disabled, you're going through a CDR, continuing disability review. They want to remove your benefits. You make a statement on the record or you go in front of a judge pertaining to essentially, whether or not you're still disabled, and you say on the record that you are smoking cigarettes. Well, right there, you have just introduced to the evidence the likelihood that you are using the funds that you receive from the Social Security Administration for disability benefits for cigarettes. Now, cigarettes were not such a bad deal or big deal in the 60s or the 70s. The 80s, they became a big deal. The 90s, they became a huge deal. The early 2000s, they were a mega deal. Nowadays, you are not allowed to smoke using the money that you receive from the Social Security Administration for disability benefits. I just want to make that super duper clear. I want it to be understood at a very simple level. I want you to basically just, if you're aware of this and you are smoking, be aware of your statements, and you need to stop smoking using the government's money because they will take the money away from you, and it will be simply because you used it to buy a pack of cigarettes. Something to consider. Another thing that is happening with the 2019 adjudications, and this is kind of the overall how things are working, is that attorneys are now more restricted in when the hearings can be scheduled. And attorneys now need to give all this information ahead of time to tell them when they will be available, which is a problem because if an attorney is sick and they don't have a backup attorney at their firm, then all of a sudden their attorney isn't going to be present at the hearing. And sometimes it's okay, sometimes it becomes a whole hassle. So attorneys now, I think it's 4 to 6 months, and they haven't really come out with a specified rule yet. They're just kind of telling attorneys at this point what's going on. But it's 4 to 6 months. They have that to go ahead and notify the SSA ahead of time of when they're not going to be available. Which means that all the attorneys have to create this list of when they're not going to be. This is for reps too. I say attorneys because honestly, I don't know why you would ever hire a representative or a hospital person, or I don't know why you would ever hire them to basically do this when you could have an attorney doing it at the same rate. That just boggles my mind. Some of you are still making that stupid mistake, but a lot of you are wising up, which is good. So it's not really as big of an issue as it used to be. But basically, attorneys now and representatives and agents and yada yada have to notify them way ahead of time when they'll be available, which means that your hearing date, even if you're not going to be available, it gets set. Whether you have to be at some medical appointment for an MRI, whether or not the attorney has to do something similar to that, it's set in stone. That's it. You change your life for this hearing. Now, I understand it's incredibly important, but the way it used to work was the better way. They would call the law firm would call the claimant, they would check, make sure everything's good with everybody's schedule, they would schedule it. Apparently this was too tough, or too time consuming, or whatever you want to attach to it. So at the end of the day, those are the things that have changed, the very big things for 2019. The bottom line is the process isn't getting easier, it's getting more structured, it's getting more bureaucratic, it's getting more government, pro-government. It's not changing in a positive way for the claimants. So just keep that in mind as you begin your process to go ahead and apply for Social Security disability benefits. My name is Attorney Walter Rudolph Hnot III. I'm with Disability Resolution PA. Phone number is 407-279-1754. 472-797-1754. The email is info@disabilityresolution.com. It's always in the bio area below somewhere. What you need to know is this: if you'd like a custom video made on a particular topic, that's fine. Shoot me an email, give me a call. If you'd like a free tutorial, that's fine. Shoot me an email or give me a call. And at this point, I've made more disability tutorial videos than any other attorney in the world. So if you would like me to touch on a topic, I'm more than happy to. All right. Any questions, anything at all, shoot me an email and we'll go from there. Thank you so much. Have a wonderful day. Bye-bye.